Custody disputes can get messy. Fathers across Texas say they're fighting to see their children because their child's mother won't follow court orders, which is a felony in Texas.
Our chief investigative reporter, Genevieve Curtis, is digging into this issue. She is live in the studio with more on this. Jen.
Robert and Erica, parents say a lack of enforcement when it comes to child custody is keeping them from their kids. This is an issue KFOX 14 investigates, first reported on in 2014, but dads tell me they continue to have difficulty seeing their children. Tonight, we follow one father as he tries to get his rightful court visitation, and we examine a broken system keeping families apart.
Well, my daughter's 5 years old.
It's hard for Chris Dunphy to even talk about his 5-year-old daughter, Rosie.
She's a very outgoing, smart little girl. Okay, get a minute.
Dunphy and his wife live in Austin, but he drives to El Paso for his court-ordered visitation with his daughter. The order states he gets the first, third, and fifth weekends of the month.
I mean, I want my daughter to have a stable home, a loving home, to grow up to know that she will have nothing to worry about.
But he says his daughter's mother has refused to honor the agreement. Last year, El Paso police took a report for the mother's interference with child custody. But Dunphy received a letter from the district attorney's office saying they would not prosecute the case or file formal charges.
Did you even look at the case?
2018 records from Child Protective Services show caseworkers are concerned about a pattern of domestic violence between the mother and her boyfriend. CPS says the children are at, quote, substantial risk. Jail records showed the boyfriend was arrested on family violence charges in 2017 and 2018. In 2018, he was convicted of family violence and violating a protective order and sentenced to 100 days in jail. And still, Dunphy can't see his daughter. He's not the only father facing this problem. Records obtained by KFOX 14 Investigates show there were more than 4,000 reports taken by the El Paso Police Department for child custody interference from 2016 to 2018. 229 of those cases were presented to the district attorney's office. Only 11 were indicted. That's just 5% of cases presented.
So I'm stuck in this limbo where I'm trying to see my daughter.
Dunphy's court orders state any peace officer can enforce the order. Interfering with child custody is a state jail felony in Texas, which means you can be locked up for up to 2 years. But dads say in El Paso, it's not being enforced.
They just say, sorry, sir, it's a civil matter. We can give you a report, and they'll conduct an investigation and see where it goes. I'm like, you guys are not going to do anything? They're like, nope. DA said not to do anything.
KFOX 14 Investigates went with Dunphy as he tried to pick up Rosie from daycare. The daycare wasn't sure if it could release her to him. As they waited for police, the mother showed up. And once police arrived,
How's it going, sir? I'm here to I'm here to exchange custody.
The officer read the agreement.
I can't physically force her. Okay.
Okay.
So I'll be doing a report for her interfering with child custody.
But the officer told Dunphy he can't physically force the mother to comply with the order.
Okay. I'm already told her you need to relinquish it. And if you don't relinquish her, I'm going to do a report against you.
Okay.
And she said she doesn't care.
The officer said he would file a report for interference.
When are you going to enforce the law? Like, it's a criminal offense. You're allowing parents to get away with this.
KFOX 14 Investigates first reported on this issue in 2014. Back then, District Attorney Jaime Esparza told us it's a gray area.
There's a fine line between when does the civil conduct, the civil wrong, actually bleed over and become criminal conduct.
6 years later, it's still an issue. So we asked Esparza why so few of these cases are being prosecuted by his office. But his office said he would not be available to comment this week. The mother didn't even let Rosie hug her dad as she took her out of the daycare and past our camera.
I'll see you next time, okay?
Dunphy knows he's not alone in trying to get time with his child.
My name is Ann O'Keefe Rogers, and I am an alienated mother of 4 children, 3 of whom are alienated from me. And I wanted just to spend a little bit of time explaining my story, but my story has a purpose. So I'm happy to share my story with the hope and intention that any alienated parent or child who sees this video will be able to learn. Because it's one thing to tell a story around the campfire, but if that story has no meaning and no opportunity for growth, that's all it is. It's a meaningless story. So I wanted to share a little bit about my journey of parental alienation. In 1993, I got married, and ostensibly under good circumstances. We thought we were a good fit for each other, and we had 4 children. And we were married for 16 years. The beginning of the end of the marriage included my diagnosis of thyroid cancer. And in 2005 is when the first initial diagnosis came out. And 6 months later, I lost my father after a 16-year battle with Parkinson's. So within a 12-month period, I had our 4th child. I lost my father. I was diagnosed with thyroid cancer, and our only son was diagnosed with autism. And that was the beginning of the end of the marriage. It was a high conflict divorce. And it was only with the passage of time that I saw things that were going on during the marriage that I was unaware of. So with the passage of time, and after a lot of reading and a lot of study and a lot of prayer and community support, I've actually been able to grow in this journey of parental alienation. The first time that I felt something was wrong was during the marriage, when there were interactions with my then husband, and he would say or do something, and in the back of my mind, I thought, that's really off, and that's really weird, but you know what? He'll stop doing that. And once we have children, or once I get a different job, or once he gets a different job, that won't be an issue. And I kept doing this over and over during the marriage. And those were the first initial signs that there was something unhealthy in the marriage. And in a lot of ways, I do feel that I was played, that I was used. I was a full-time mother. And taking care of 4 children under the age of 10 is not an easy thing to do. My husband did travel a lot for work. And so essentially I was a single parent half the time. And I had no family in town. So in a lot of ways, I was used, and I felt that way. But at any rate, the marriage did not survive, and court began. And as soon as the legal process began, that is where I saw how unfamily friendly our legal system is. Multiple rounds at court, multiple hearings, depositions, and I have an entire banker's box full of the paperwork, because there was absolutely no reason why I should not be able to continue to parent my children after the divorce. And yet, as somebody I worked with during the time of the divorce told me, he said, "Anne, you're bringing a knife to a gunfight because of the imbalance of power." My ex-husband had a lot of connections. He had a lot of money. And in a similar way to like the O.J. Simpson case shows that imbalance of power, where if a person has a legal dream team, they can get basically whatever they want. And as again, as time passed and I learned about parental alienation, I learned about unhealthy dynamics, I came to see that I was not alone, that there were many, many parents, both mothers and fathers, who go through this. I had no idea that in the state of Ohio, there's preferential option given to a parent with the higher net worth. So even though I had a very loving and positive relationship with all my children prior to the divorce, my net worth was much lower than that of my ex-husband, and his anger and his animosity is why I could only bring a knife to a gunfight. When I learned that there were other parents on this journey, and I found a support group in Ohio, and other parent stories were so similar to mine, I was just amazed. And we shared tips, we shared our struggles, but we also shared our successes. And I want to share that there was one other alienated mom who I met 8 years ago at a parental alienation support group. She and I still check in every single day. We pray for our children by name, and we pray for our ex-husbands. Her journey is so strikingly similar to mine, and she has 3 children in similar ages as mine. So that kind of support is so essential. Went over with, it was the support group. There is a gentleman, his name is Howie Dennison. You can find him on Facebook, and he heads the Central Ohio Parental Alienation Support Group. His website is like the Library of Congress of science and research on parental alienation. And I highly recommend that any parent who would like more information about parental alienation from good and trusted, credible resources, they could check that website out. It was gradual. Like I said, the relationship with my children was very positive and loving during the marriage. And the court ordered at first shared parenting. And it was 2 nights a week and every other weekend. During the time of the shared parenting, my oldest 2 children slowly began to shift in their attitude and their behavior toward me and my entire family of origin. And there were issues of disobedience, aggression, disrespect, going through my personal items because they were told by their father they needed to look for things to try to get me. And at the time, we had a guardian ad litem. And so the guardian ad litem saw this, and they attempted to use this against me, but yet they couldn't. So at any rate, it was a very slow and gradual process. And then my ex-husband would not rest until the final settlement would be the children would choose their visitation time. And to put an 11-year-old in the position of having to choose how much or any time to be spent with their parent, that is child abuse. We do not ask children whether or not they want to go to school or go to the doctor for their checkups. We don't ask them that, whether or not they want to. And that is a crime, and it is child abuse. And that is why parental alienation is child abuse. So the time when I was kept with my children was basically court sanctioned. The court saw that that was the best thing for my children to be able to choose. Now, at that time, my oldest was 11 and my youngest was 2. How can, again, an 11-year-old or a 2-year-old choose? My worst experience with court was when the magistrate found out about the parental alienation. And this was at the end of a hearing on another matter. And when she knew about the fact that my daughters had been rejecting me and my entire family of origin for over 5 years, the magistrate told my attorney, what about, I'm not going to say her name, the name of my youngest daughter, who hasn't had any time with her mother, and you'll have to file another motion. And my attorney said, we will come back for her. We will come back. And then COVID hit. Many, many parents became financially drained, and they were unable to file additional hearings. So again, what my other attorney had said was knife in a gunfight. So that was my worst experience at court, where the magistrate knew about the abuse. And yet she said, another hearing, you're going to have to file another motion for another hearing. I will not address. She knew the abuse was going on. And she's like, well, basically, stinks to be you, Anne. I know about the abuse that's going on with this. At that time, my daughter was 13. She's like, well, oh well, move on to the next case. Gotta go. When she knew it had been, at that time, it had been 5 years that I had spent any time with her, for no other reason than the animosity of my ex. My ex-husband had an image to maintain. He was in control. He had the money, he had the power. He was trying to prove that I was psychiatrically unfit to parent my children. And yet he could not get a single doctor to say that. I went through the psych eval at his demand. It came clean, and my ex-husband said, oh, that doctor's whack. That psych eval is meaningless. So again, to have another psych eval through the courts in Ohio, the amount of money that it would cost would be close to $100,000. So for parents who are independently wealthy, of course, they'll go ahead and get it. They'll get it done. But not everybody is independently wealthy. Again, a knife in a gunfight. I said a story that has no meaning and no takeaway is meaningless. And I want my story to be heard not because I want pity or sorrow. I want to let everybody know I learned, I prayed, and I grew. I grew stronger, number one, in my faith. Number two, I grew stronger in the science. I became a certified family life educator. I took the certification test this summer and I passed it on my own. I immersed myself in the science and the research. What goes into a healthy family? What makes for an unhealthy family? And right now, as we're recovering from the pandemic, there's so much suffering because the lockdowns and the restrictions have hurt so many people, and the mental health impact is huge. So I am an advocate. I work with others to provide resources for alienated parents so that they get good information, good resources from credible sources. And I am on the planning team for a retreat in April for International Parental Alienation Awareness Day. It is April 25th every year. And I encourage all alienated parents to do the same thing. Immerse yourself in knowledge, in science, family science. And when your children have been ripped away from you by the court, it is horrific. All of us have PTSD to some extent or another, but treat that PTSD the same way you would treat it if your doctor told you you had cancer or diabetes. Learn about it. Learn about how you can be strong and live a life of credibility so that if and when your children choose to come back to you and your family of origin, you will be strong. And that is how I want to leave the end of my story. Be strong, find support, find other alienated parents who will strengthen you. And thank you so much for this opportunity.
My name is Sarah J. Johnston. I am a parent advocate for family law reform, focused mainly on 50-50 and the benefits that it has for the children, women, and men. I am the stepmother in one of our community's celebrated co-parenting teams. By that, what I mean is that my husband, his ex-wife, her husband, and myself work together as co-parents under a 50-50 parenting plan to parent my stepson. So that's a little bit about myself. So one of the reasons why I support 50-50 is because I have seen it happen within my family and I've seen it happen within other families. So one of the great things about 50-50 is it's kind of this magic pill that takes a lot of the conflict out of your situation. One of the big things about custody fights and divorce and two parents who are trying to co-parent but can't get along is that our family laws create a winner and a loser situation. So you have the custodial parent who is the winner, and then you have the non-custodial parent who is the loser. The great thing about 50-50 is it puts you on even ground. It gives the children, who should be the main focus in all of this, equal time to build a relationship with both their mother and their father. It also, because it does take that high conflict out, it helps them realize that this may not be a nuclear family, but we are still a family. You are still the most important thing here, is making sure that you are happy, healthy, and that you are raised well. This would be really important for children whose custodial parent is actively trying to participate in parental alienation. So one of the things in being a part of this community that I've learned is that custodial parents oftentimes disregard a parenting plan. They don't want their child or children to have a relationship with that other parent. You failed at your relationship, so they're going to use their custodial parent status in order to damage your relationship with your children. When you have something like 50-50, when the entire concept and all of society and the expectations from the judge are that you're going to co-parent and it's going to be equal time, that kind of removes a lot of that ability to do that. Not only that, but studies have shown that even in high conflict situations, 50-50 insulates the children from the negative impacts of that parental alienation. It secures their relationship. It secures their self-esteem that comes from having that relationship with both parents. It is exceptionally important for these children in order to have a relationship, in order to have that time. Because yeah, a lot of times quality is over quantity. But you can't have quality time when we are talking 4 days a month with that parent. That's not enough time to build that quality. And that's something that children really desperately need.
Chair calls Sarah J. Johnston. And after that, Bethany Holick. Can you please state your name, whom you represent, and your position on the bill?
Okay, give me just a second. I got to get my glasses on so I can see you guys. I just can't wear it with my mask. My name is Sarah J. Johnston. I represent the Fathers' Rights Movement, and we are, of course, for this bill. I had a whole testimony as a 50-50 mom. You guys saw my son. He was up here just a little bit ago. But we're not going to talk about that because I've had to rewrite my entire thing just this evening. I can get you those stats that show that 92.47% of custodial and guardians in the state of Texas are women. Also, the code actually states the presumption that you have to beat when you first walk in the door is that standard possession is in the best interest of a child. We all are very well aware with the stats and the studies that that's a lie. That's actually damaging to our children. It's endangering them. So there's also this thing this evening where it seems like everybody wants to believe that the men of our world are dangerous to their children somehow. However, in the country of Australia, They did a study due to the increased amount of felicide that has been happening. It was a 12-year study. What they found is that 46.83% of the children murdered in that 12 years were murdered by their custodial mom. 14.47% were murdered by their stepfather. Custodial mothers and their significant others pose a much greater risk to the children than non-custodial fathers, which only amounted for 9.88%, and their significant others were noted as 0. Now, as a child of severe child abuse, to include attempted homicide, the fact that people get up here and they want to talk about, they want to use children like me as an excuse to harm to a much larger population to children, I find that offensive. We're talking about all of the children of Texas. Do we want to lose any of them to child abuse? No, of course I don't. But we have to be careful, and we have to make sure that we're not hurting millions of children over this idea that's certainly proven through study and through science as not valid.
Thank you. Thank you for your testimony. Members, are there any questions for this witness? Chair recognizes Representative Cook.
Where can I get the stats that you're referring to, the 92.47%?
It's actually from public information requests that we asked. We asked for the child support that goes through the Attorney General's office and the breakdown of the relationship to the child. We can actually provide that for you. We have it in PDFs and we have it in Excel spreadsheets.
So there's not a document from the Attorney General's office?
Their website does say over 90% are women.
Okay. And then as far as the Austin form, did y'all look at those as far as, like, you know, when you do a divorce, there's a form that you have to fill out each time you do a divorce? I was just curious if that was part of the research or not.
No, I don't believe so, but I'm not the one who requested it. Taryn Champagne would be the one that would be able to better answer exactly what information was on there. I know we just did a request with the breakdown.
Okay, thank you.
Thank you.
Members, any other questions? Okay, thank you for your testimony.
One of the saddest parts about being an advocate is when you go up to the Capitol, how parents that are fighting to try to get these laws changed are treated by some legislators. So in my case, there's not really much anyone can do against my family because we are all co-parents, and you're not really going to get in the middle of us and cause a kerfluffle. However, some parents are being treated at the Capitol as though that they are some sort of criminal for simply going up there and trying to fight for access to their children, fight for their children's mental health, fight for their children's rights to access to both parents. Some great examples of this would be this previous session. When I went to go meet with the legislator's office, it took me months of calling and following up and following up and following up to finally get a face-to-face meeting with their office. I couldn't even get a Zoom meeting with them. And when I went up to the Capitol to meet with them, I did not get treated as I would expect to be treated, and even how I've been treated by other offices that aren't interested in supporting the bill. I did not get to meet with the staff in their office. I was shoved out the door, and I had to go meet with the representative from this state representative's office in the hallway on a bench, as if I were, I don't know, some sort of like cholera patient, someone with some sort of leprosy, because I support family law reform. It was very odd. It was very uncomfortable. And I find that very unethical that a representative who is supposed to be representing the people of Texas, because for whatever reason, they don't support the bills, refuse to treat the actual voters in Texas. We're not lobbyists. We're just parents that are coming in there trying to talk to them, that we can't even get the courtesy of meeting in their office. We have to meet them in the hallway as though it's some sort of cloak and dagger situation where they don't want anybody to know that they're meeting with parents to talk about these family law reform bills. Great examples of this also are, if you look at the testimonies for HB 803, there are many times where the men of Texas who support family law reform got up there to testify, and some of the representatives were just outright ugly to them, asking them questions. Some of the statements that were made were just super derogatory toward men in general. There was much testimony that happened. There was a lot of it that was focused on some claims that men as a general rule are dangerous to children, which were never supported by any facts, any studies, because there are none. And I found it to be more of a circus, that the representatives were not only allowing that and not asking questions about their statistics, but they were encouraging it. They were repeating the same lies and false information that many of these groups push out. Not only that, but then when people like myself got up with actual data that was done through public of information requests from the Department of the Attorney General's office, we were hounded. We were questioned. We were hounded. I was essentially called a liar in the middle of the hearing. Same representative called me a liar outright in other discussions because they don't like the numbers that we gave. And the funny thing about that is that the Attorney General's office even says on their website in their non-custodial parent that 90% of non-custodial parents in the state of Texas are men. But when we get up there to testify for this bill and we are backing up the numbers from the Attorney General's office like ourselves with their data, it becomes a problem. One representative went on a tirade about how she feels that 50-50 is damaging to kids because they live in a suitcase and all of this other hoopla. And for anybody who watches the testimony, my stepson Jeremy got up there and he completely explained that it was an incorrect statement. The representatives who were against 50-50 because they claim that how children would feel had the perfect opportunity at that hearing. They had a child who does 50-50, someone who has done 50-50 the majority of his life. They could have asked him questions. They were all given the opportunity before the hearing to talk to him, to ask him questions so he can answer anything from a child's perspective. Not one of those representatives asked him any questions about what it's like for him as a child. So they got up there bashing the parents. They explained to us how the children would feel. They explained to a child who does it how he should feel without taking the opportunity to actually ask him what it's like. That's not what we vote for these people to do. We don't vote for representatives to go up there to represent us, to tell us how we should feel about things. We vote them in so they can go up there and represent how we feel about things. Not so they can be the overrulers and tell us how we have to feel about things. It's really disgusting to me the way that a lot of the parents are treated. A lot of the women who got up there to testify because they were mistreated in family court, there was one woman who lost custody, primary custody, because she's in college. There was another woman who testified about how because she has a high power job that she was not given primary custody. And rather than admit that this is a problem, yes, we understand, they really attacked those women. They really just went after them. So to me, it's not just the fathers that are being treated negatively by our state representatives when we talk about family law reform. It's the women. It's the women that they claim that they're out there fighting for. They claim to be feminists. They claim they want to help us get ahead because women, the pay gap and the this and the that. But when we take them legitimate data, statistics, stories from women who have been mistreated in the family courts, they treat them as though they have done something wrong by not being a stay-at-home mom, by wanting to better themselves. Well, there has to be a reason. You had to have done something wrong. Or it's just our family law needs to be fixed because it's broken. One of the major misconceptions that we see in this realm is that the opposition to family law reform, which would give children equal access to both fit and willing parents, they often talk about the fact that they claim that fathers are somehow more dangerous to children than mothers are. And the thing of it is the statistics and the studies are not on their side. If you look at the Australian study that was done about parents who murdered their children over a 12-year period, what they found is that custodial mothers and their significant others, they are a much greater risk to children than non-custodial fathers, custodial fathers, and their significant others. If you look at any data from the state of Texas, just itself, about the abuse that is found through CPS or any other reporting agencies, what you're going to find is that the number of custodial mothers who are the criminals in those cases are much higher than dads. The number of significant others to a custodial mother are much higher than non-custodial fathers. So for the people who want to say that fathers are somehow super dangerous to their children, I just think that we all need to demand and require the studies, the facts, everything about that. Because if you look at, there are some studies that claim this, but if you look at the way in which that they are pulled together, they're not done in a scientific manner. They are pulled from very specific pools of court cases. And when you limit your study to only specific court cases, you're sliding the scale over. So if you only look at cases where there has already been an arrest of abuse, for example, of course you're going to find that the majority of the cases in your study are going to have that. You have to do a much broader look at it. You have to look at the pool of court cases as a whole. You can't only look at one small sample and then act all surprised that your results match your hypothesis. That's not how scientific studies are done. Also, for somebody who, like myself, who my sisters, myself, my mother, we were extreme victims of domestic and child abuse when I was younger. And that's something that I just don't think these people understand, is you are insulting me, you are insulting other victims by getting up there and trying to say that my case is the same as your child's father not taking him to a birthday party on his Saturday because he wanted to spend his 4 days a month with his child. That's not the same. That's not remotely the same. You know, having your face busted up and having lifelong trauma is a completely different aspect than he just failed at the relationship with you, so you're trying to damage his relationship with his children. And so I don't think that a lot of those people that advocate for that think of that, of how insulting you're being to actual victims of abuse, how much you are tying up the resources of the state, of the nonprofits that are there to help actual victims. You're tying up those resources and you are leaving actual victims of abuse out there to continue to be abused because you are clogging a system with your ridiculous claims and your lunatic ideas that just because a father wants to parent on his time in a healthy and appropriate way, that he is somehow abusing his children because he's not following the rules you set forth. 50-50 will really help eliminate things like parental alienation. When you tell both parents that they are equal, then they are going to behave more in an appropriate manner. When you tell one parent that they have the ultimate power over the other, then they walk away from family court thinking that they own those children. They own that relationship the non-custodial parent has with those children, and that's inappropriate. The great thing about 50-50 or equal shared parenting or just family law reform in general would be we need to remove that idea. We need to make sure that when people walk out in a family court, they understand that both parents are equal when they are fit and loving. We are not talking about situations where there are abuse. We're not talking about situations where we are having issues with drugs or alcohol. We are talking about two fit and loving parents. If a non-custodial parent is found fit to have a child 4 days a month and to build that relationship with that child, there is no reason that they cannot have additional time and that child gets additional time with their parent. On top of that, when we put one parent in charge of everything, they, no matter how good of a person you are, when you have extra power, sometimes you use that. That's not to say that all people who are doing this or using that or abusing that are necessarily bad people, but they don't understand that they are in fact a child abuser. And that's the thing that concerns me. The thing that concerns me here is that we could make some changes to the family law and we could put parents as equal. We could put children first. We could remove the psychological, emotional, damaging practice of parental alienation for the most part. And we're refusing to do that. We're refusing to do that because people say things like, you guys are just wanting to put moms in jail. No, we're wanting to put child abusers in jail. If it was somebody who was beating a child and leaving bruises, there would be no questions that reform was needed. However, because it's emotional and mental scars that this parent is leaving, everyone acts as though we're attacking just the custodial parents. And we are not attacking all custodial parents. We are wanting the law to hold child abusers accountable. And that is all there is to it. The state of Texas has a penal code 2503, which is interference with child custody. It is a state jailed felony. Here is the problem with that, is we act like that law is out there, and so we don't have any problems with custodial parents refusing to follow the parenting plan. We act like that there's no issues with parental alienation in the state of Texas. But the bottom line is if somebody calls for interference of child custody, a non-custodial parent is there to pick up their child, the majority of the time they are told by the police officers that it's a civil matter. Now, in the back of all of our decrees here in the state of Texas, there are instructions to police officers on how to go about enforcing the order if they get that call. However, they're not following that. They are not, as a general rule, writing an offense report for a 2503 violation. DAs are not prosecuting 2503 violations. Again, we're back to that, you just want to throw moms in jail. No, we want child abusers to be held accountable. If you are guilty of repeated interference with child custody, repeatedly denying parenting time to a fit and loving non-custodial parent that was given their parental rights in family court, you are abusing the child or children involved. You are mentally and emotionally abusing them. 2503 and parental alienation, the focus of these should not be on parent against parent, mother against father. One of the things that everybody needs to start paying attention to, and they need to be focusing on, are those children. How does it impact those children? How does it impact them physically, emotionally, mentally? What does it do to their self-esteem? What does it do to their belief in people, their belief in the system? What about the stats that show the majority of children in the state of Texas have a custodial mom and a non-custodial father? So typically, they become fatherless. You're denying parenting time and evolves into parental alienation. You are abusing your children because you are making them fatherless. You are removing a fit and loving father from their lives. Those stats don't lie. 85% of the youth in prison are from fatherless homes. 90% of runaways, fatherless homes. These are things that we all need to be focusing on. Not whether it's mom and dad, not whether it's custodial parent against non-custodial parent. The bottom line here is, how does this impact the children? I don't care if you put people in jail. I care that you stop the abuse of children. One of the main misconceptions I think that comes out of family law reform is that the advocates for family law reform are against women. They're the anti-feminists, and the representatives and the lobbyists that are working for the lawyers and want to keep family law the way it is, they are feminists. They are fighting for our rights to do everything we want, to be a mom, to have a job, to do everything. But when you actually look at what happens in family law and you look at all of these things, look at singlemommy.com. Singlemommy.com did a survey about 50-50 and standard custody agreements. And what they found are women with 50-50 make a lot more money. They have a lot more time for self-care. They are overall more satisfied with themselves and their roles because it's not all on their shoulders. So the funny thing is these representatives who are against the reform, they get out there, and I saw one representative attack a man who asked her about her support for squashing the bills, and she attacked him for being a man. And my response to that is, what have you done for women? Because what you've done by squashing family law reform bills is you claim that you want to let women be out there and in the work world, and we can climb any mountains, we can bust any glass ceilings. But what you're actually doing is, when we go into family law, is you are very quietly shoving us right back into a 1960s stay-at-home mom role. So 90% of custodial parents, according to the Texas Attorney General's office, are women. Women do not have the support of having another parent. They don't have the support through family law to be able to lean on the non-custodial parent outside of the parenting plan. Because if you do, that non-custodial parent can take you back to court and you can become the non-custodial parent. There is nothing in the family law that supports the feminist ideas. There is zero that supports a woman having a high-powered job, going to college, and being a mother. When you go into family court, you are a mother, and that is all that you are going to be. Because if you do anything else, as we saw in the HB 803 testimony, one mother lost custody because she was in college. One mother lost custody because she has a high power and high demanding job. So we're okay with that because they don't want to have reform. So the question is, why don't they? Why don't these representatives who say that they support feminism, that say they support women in the workforce, that say they support the idea that we can be moms and we can have high power jobs, why are they refusing to even listen or entertain bills that would put the parental roles even between fathers and mothers? Why are they sitting there only supporting a family law system that puts 75% of the parenting, if not more, on the mom? Yet they want to talk about how dads should step up. Well, then let them change the law. Make the law where dad has the ability to step up. Let him. If you want to support women like me who are parents and who work and who feel like that we can do anything, then change the laws to reflect that, so that when these young ladies go into family court, that they are not being told that they have to choose between their job, their self-care, and being a mom. It is not a hard concept. And if you want men to step up, then give them the ability to do that. My family has, at times through our 17-year journey in the family law system, been what people call high conflict. We have fought, we have gotten down and dirty and ugly, and all of that has come from the fact that that's encouraged. That is encouraged from lawyers, that's encouraged from society, that's encouraged in everywhere you look. And the great thing about 50-50 is that once we started doing that, that toxicity just went away. We were able to find a middle ground where we are one group of 4 adults who are raising a child. We rely on each other. We each have our own niches for what we take care of. We each teach him something individually, something that he wouldn't have gotten if just the 2 biological parents were involved. We have taken the 50-50 and we have run with it. The families that I know that have 50-50, we're not the only ones that have found this to be the cure for the issues. Are you always going to find that it works 100% of the time? Of course not. You're going to have some of those personalities that just can't get along. But the thing of that is it still keeps the kids happy. It still keeps the kids in contact with both parents. It gives them a healthy relationship with both parents, and it lets both parents be parents. If you stop letting parents be parents to their children suffer. 50-50 will stop the abuse of children through parental alienation, through legal abuse from constantly having to go to court, from false allegations. There are states that already have this, and what they have seen are that the numbers drop. They're having success. Children are having success from this. I've seen it with my child, and I know that this is something that will help the children of Texas. There are representatives who support it. We had so many co-authors on this last session, so many co-authors who really saw the stats, the data, who took the time to talk to Jeremy, who took the time to talk to the parents who do 50-50, who took the time to talk to the parents who were fighting for their children's rights. We just need to make sure that those other representatives see the light, that they look at this as the truth of what it is, and that we stop allowing a lobby group who's here just to defend the paychecks of the people who pay them to keep families in court fighting, to keep the abuse of children up, to keep those parental alienation numbers up, because every time you have a parental alienation case, that lawyer's getting more money. They make money from the abuse of children. Family law reform would save children from that same abuse.
Hello, I'm Dr. David O'Connor. I'm a board-certified adult and child and adolescent psychiatrist. For approximately the past 25 years, I've practiced in a variety of clinical settings and served in several past administrative positions and currently provide clinical care to adults and children of all ages, and also perform some administrative physician review work as well as other utilization review work. When applying the current Texas Family Code to children of divorce and children in which parents are not cohabitating, the Texas Family Code does promote a relative separation of the children from one of the parents. So why do we say that? Well, with the Texas Family Code, what occurs is that parenting roles get divided into a main custodial parent as well as a non-custodial parent. And the non-custodial parent, relatively speaking, is minimized from the child's life. In most cohabitating or marriage situations, the children have free access to both parents. And in a majority of the situations, both parents see the children and the children see their parents almost equally. Of course, there are exceptions. depending on the variety of work schedules that are occurring with the mom or a dad in the household. When following or applying what is the Texas Family Code and the parenting times, which is commonly called possession times, the parenting roles get divided. As I said earlier, there's a main custodial parent with which the child lives with, and then there's a non-custodial parent. The percentage of times in the family code that the non-custodial parent, which is most commonly the male or the father, the child sees, relatively speaking, 30 to 40% of the time. And the remaining time, 60 to 70%, is the child is relegated to stay with or live with the custodial parent. It is almost as if the custodial parent is the main parent and the non-custodial parent becomes almost a visitor. And this is the message that the child or children receive. It promotes actually an imbalance of roles and an imbalance of parental responsibilities and parental involvement. And the children get this message. Now, what is commonly advertised to parents is that they must follow this strategy, this Texas Family Code. What's not commonly advertised to parents, unless they gain the knowledge themselves and resolve the issue of their separation or divorce themselves, is that they really can decide their own parenting plan. So in summary, when we're going from a situation in which children have equal access to both parents, for the majority of cases, have almost equal time with parenting roles and parental parenting times, going to not only loss of the family structure or the cohabitation structure, but relative loss of one of their parents down to 30 to 40% of the parenting time compared to what they used to have. That's a significant loss for children. And it's more significant the younger the child is. For little children, time is of a different perspective than for us as adults. And that's relative to the entire length of their life. So when applying this to a 1, 2, 3, 4, 5, 6-year-old who go from equal access to both parents to less than equal access, and they're not seeing one of their parents for several days in a row, because that is more significant relative time period compared to adults, they do experience an issue of abandonment. In our field, this would be a form of abandonment trauma. There are many experts in the field that have written extensively about this. One of them, which one of my colleagues and I discussed with, is Edward Kruk. And Dr. Kruk is an associate professor of social work. And Dr. Kruk is an associate professor of sociology at the University of British Columbia. And he did an evaluation or analysis of the Texas Family Code. And viewers can refer to that analysis at their own leisure. So what essentially occurs is that children have a relative loss of one of their parents. Many would argue that this fulfills the criteria under Title 4D of creating a relative loss of one of their parents, which is a criteria in order to receive federal subsidies from the federal government to the states. There is an evolution of this that for a long time has just been passively accepted as the way it is. In the Texas Family Code, it's statute that Title 4D associate judges are to maximize child support income by, quote, whatever means necessary. And in the capital of Texas, Austin, Texas, which resides in Travis County, by Office of Attorney General Statistics, as late as 2020, 98.3% of non-custodial parents are the fathers, and 1.7% of non-custodial parents are the mothers. Statistically, when applying the Texas Family Code and it's what is now the expanded standard possession order, before age 5 or before 5 years after separation, relative separation, or non-cohabitation, approximately 40 to 60% of non-custodial parents will essentially gradually drop out of care and involvement in their child's lives. And of course, a smaller percentage will drop out earlier, and a smaller percentage will maintain involvement in their child's life and be involved in co-parenting or parallel parenting with their children and their exes. There can be many factors involved in this that are contributed to by one parent or another, or both at times, and also by the beliefs or knowledge of the family law attorneys involved and by the judiciary. So would it be reasonable to say that when there's an induced relative absence of a parent from a child, that this could be a pushing away process? In other words, in the start of an alienating process? I think it would be reasonable to say so, that the current Texas Family Code does create a pushing away of the child from one of the parents. Another part of this is, depending on the psychological, emotional, and situational status of each parent, there are cases in which the custodial parent will also attempt to push away the other parent. Now, the process in which one parent can or attempts or will push away the other parent out of the child's life can be very complicated. And it not only will involve the parent themselves, but unfortunately it can involve the family attorneys involved, and it can also involve the judiciary that's involved when they are involved. An important issue is that the issue of separation, whether it's by divorce or non-cohabitation, is in itself, even in healthy adults, can be a traumatic period. It's a period of grief and the process of grief. And depending on the developmental background of each parent, now when one parent or the other is not able to go through the grief process, the separation process, and come to some resolution that the type of relationship that once was with their ex-spouse or ex-partner, and able to come to some conclusion about that and transition into another type of relationship, which would be a co-parenting relationship or a parallel parenting relationship, then that grief process never ends. Neither family attorneys or judges are fully educated to understand all that that can entail. So invariably, the stages of grief, whether it's shock, anger, sadness, denial, can continue to go on and be applied toward the ex-spouse, and the children are brought into it, unfortunately, as part of the conflict. By nature, children want to love their parents. By nature, children want to be loved by their parents and accepted by their parents. That's part of the nurturing process. So it is not natural, with exceptions, of course, that one parent would want to separate the child from another parent. Now, this process of inducing separation of the child from the other parent is, in and of itself, by definition of the word alienation, an alienating process. That's already begun when parents follow the Texas Family Code or family codes of a majority of the states in the United States. And then when this attempt to push away or alienate one parent that's by another parent, and continuing this process of attempting to alienate, the alienator or the alienating parent will do this in a multitude of ways, which is beyond the scope of this presentation. It can range from very subtle manipulation, psychologically, emotionally, to very overt actions. There are several characteristics of parents that want to alienate a child from the other parent, which for the most part would be on the scope of this presentation. But the tactics would involve eventually, gradually persuading the child to reject the parent themselves. And this can become a very insidious, gradual, difficult to identify process. And the outcome desired is not only to push away the parent, which we call the target parent, but it is also to emotionally or psychologically harm the other parent. Keeping in mind that the alienating parent is usually still stuck in this separation grief process. They never come to some resolution, some letting go stage, as would normally occur with human separation. Other parts of the alienating process, which have already begun with the separation of children from their parents using the expanded standard possession order, as well as many possession orders in other states, as they're called, is also propagated by the pushing away parent or the alienating parent utilizing their attorneys or their friends, other family members, and even the judiciary to assist, many times unknowingly, in the process of dividing the child from the other parent. Now, as was touched upon minutes ago concerning Texas Family Code, the relative absence of a parent, the issue of federal subsidies, the other part that comes into play is Texas separates itself distinctly from other states, and that it has a main lobbying group that advocates and promotes the maintenance of this separation process through the Family Code. And approximately 6 to 7% of all family law attorneys are members of this main lobbying group. And it's well documented that the information, what we would commonly call propaganda or false information that's provided to legislatures, judges, concerning the family code, the possession order, has had several gaps in its truthfulness. I think it would be fair to say that among the judiciary, and to be fair to the judiciary, family cases are probably the toughest cases. It's a very complicated process. The judiciary gets overwhelmed with their docket. district and associate judges have to know an enormous amount of civil law, including the Texas Family Code. So it's reasonable and understandable that information received from one interest group or another interest group they don't always have time to fact check it. So it's easy to believe whatever is advertised. It's similar in my field. If we're not staying abreast of the current research and the peer-reviewed literature, and we just have pharmaceutical company representatives come in advertising this, that, or the other about a drug, without fact checking and due diligence, we might believe whatever they advertise, but we don't. At least most of us don't just go with whatever is said. I certainly don't. So one of the things that's advertised from the lobbying group to the judiciary, as well as many family law attorneys, is that ongoing conflict can never lead to co-parenting. Ongoing conflict, if it can't lead to co-parenting, there's no way that parents or the children, more importantly, can have equal time with each other. Thus, there's no way to do 50-50, which is actually not true. So what it appears is that you have this system that's incentivized to maximize child support and to maximize federal subsidies based upon child support. And since the associate judges are employees of the county and district judges are employees of the state, salaried by the state and the county, that this overall picture of parental conflict is an incentive to propagate the continued relative separation of a child from one of its parents. And as I had referenced earlier from the Office of the Attorney General statistics in 2020, such a great disparity of who is non-custodial and custodial parents, which goes beyond just by chance alone. Now we take all of that and we add into the mix that in the civil litigation or family litigation, all that's needed is a preponderance of evidence, which is a very low level of evidence required. Even utilized and applies when there's accusations of child abuse, alleged child abuse, or alleged accusations of domestic violence. Now add to the overall picture, in the courtroom, it's a litigation process. It's an adversarial process. And the attorneys involved with either parent are in the adversarial process. It's a process about winning. And although a majority of attorneys and judges are doing the best that they can, there's always that minority of attorneys and judges that come into the arena with their own particular goals, their own particular biases, that may contaminate the process. And among that minority of attorneys, their business is litigation. Their business is billing hours, not resolution, which can be a driving force to have the litigation prolonged and prolonged and prolonged. There is also other advocacy groups that will argue against what is called 50-50, stating that 50-50 promotes domestic violence or 50-50 promotes child abuse. I would disagree with that. There's no logical connection with both. I think what it shows is that when there is a judiciary decision to relegate whatever the percentage of the possession order is, later on, after there's the final hearing and the case is finalized, what can really occur in the home unknown by the judges is different than what the evidence or what's presented in the courtroom by the attorneys. And you flip the coin over, and the same is true with 50-50. Whatever is presented in the courtroom as evidence by the attorneys may not always be really what's going on in the home. And so with both points, the judges don't always get it right. In keeping in mind, the client of the attorneys is not the child. The client of the attorneys is the parent. And in the courtroom, the focus is on the parents, not on the child. So now going back to the alienating parent, the parent that pushes away the other parent, other forms that are used, other methods that are used is creating a scenario of conflict, but in a way so that it appears like the conflict is being contributed by both. Because what is perceived by the judiciary more commonly is that it doesn't matter where it's coming from, it's conflict. So there's no way that both parents can co-parent, and there's no way that the child can have equal access to both parents. In addition, the alienating parent will utilize their own attorneys to help the alienating process, and they'll utilize the judiciary, recalling that only a preponderance of evidence is needed, which is in cases of accusations of domestic violence or in cases of accusations of alleged child abuse, those are criminal behaviors. Those would require a clear and convincing level of evidence beyond preponderance of evidence, which is not even used. So one litigant, i.e. parent or the other, can make accusations in the courtroom or tell their own attorney whatever story they want, and it is believed without any, more commonly without any fact checking. And so then the judiciary will rule to separate the child from that alleged perpetrating parent without any evidence. But keep in mind that this then falls within the incentives that we spoke about earlier. So there can be utilized by an alienator multiple avenues, multiple methods, even involving the police departments. The issue of one parent alienating a child from the other parent has been extensively written. Craig Childress goes into quite detail of the background, psychological, emotional structure of parents and the needs of children that can be a driving force behind an alienating process. Richard Warshak in Dallas has written extensively about this subject. Edward Kruk has written extensively about this subject, as well as Jennifer Harmon and others throughout the world. So the whole process of pushing away a parent or alienating a parent, or I should say alienating a child from one of the parents, can start early on. It can even start prior to the divorce of a marriage or the start of the non-cohabitation status with partners. And it can continue, particularly after the physical separation. This process can be real subtle, and it's been likened to a subtle, insidious brainwashing process of the child. And it's really important that parents going through the process of divorce and separation be aware of the concept of parental alienation, because there are always red flags of indicators in this process that can be addressed to curtail the process. Because if not, what can occur is that at some point, suddenly by surprise, the non-custodial parent will find themselves being rejected by their child or by their children. And that rejection will be way out of proportion to any behavior or any behavioral interaction between the non-custodial parent and the child or children. So by knowing early on what this process can be, the different forms it can take by an alienating parent, and intervening to mitigate, mostly by dealing directly with the child. And of course, many authors have written about also being able to deal with the other parent and hopefully mitigating from that direction as well. But that cannot always occur. Not in a generalistic terms. A majority of family law attorneys are attempting to resolve the case, thinking about the children, a minority or not. And knowing the level of evidence, knowing the mindset and education, and where the education comes from the judiciary, and the concepts of parental conflict, and the concepts of utilizing accusations of domestic violence or utilizing allegations of child abuse. There are attorneys that will support, coach, and advocate that their clients use these methods in order to win the case. And this is a minority, I believe, but these things do occur. In addition, the alienating process can be or culminate into more overt forms. And we get into the subject of literally physically withholding or preventing the child from having a relationship with the other parent. Keeping in mind that children want to love both parents, and parents, they want to be loved by both parents. But an alienator will attempt to physically withhold the child or physically prevent the child from spending time with the other parent. And this can occur contrary to existing penal code, specifically 2503. In most custody orders, there is specifics concerning as is called in Texas, possession, but what I'd like to call parenting time, and the prohibition of not following the parenting time statute. And the statute is labeled 2503. When a parent withholds the physical presence of their child from the other parent, many would consider that as like the paramount offense. It is a very serious offense. In focusing on the child, it is a very serious offense affecting the child. You're forcing the abandonment trauma onto a child from separating the child from the other parent. And that's very serious, psychologically and emotionally. So as mentioned earlier, Penal Code 2503 is titled Interference with Child Custody. And in misspeaking earlier, children want to love both parents, and parents want to love their children. It can be particularly damaging to a child emotionally and psychologically when one of the parents is taken away, particularly when one of the parents is taken away by another parent. There are exceptions and specific exceptions that may prevent a parent's association with a child, but we're not speaking about those specific exceptions right now. So when non-custodial parents are calling law enforcement to enforce interference of child custody 2503, and they don't enforce or intervene in order to ensure that the child is with the parent that they're supposed to be, law enforcement is essentially enabling the violation of 2503. Now, what do we mean by enabling? Well, it's similar to when we have children in the home and we have results or consequences for behavior. And, we have verbal redirection and we set limits, and we are teaching our children how to respond to limits, how to respond to consequences and manage consequences. And let's say our child is not paying attention to us, not listening to our direction, and instead of having results for their behavior, their unwanted behavior, and results for their wanted behaviors, we just disempower ourselves. We don't have consequences. And what the child will learn is that, hey, I can get away with doing this because mom or dad is not enforcing the consequences. Now, with children, actually, they benefit with structure, and they actually like structure. And when you talk with adult offenders who reflect back on their childhood and the path that they took and the path that their parents took, adult offenders will often say, well, I wish my parents had been more firm, had been more definite in their consequences with me. So similar to rules and regulations and structures in a household, what 2503 is a rule and a regulation presenting structure for the child. It's directed at the parents, but it's presenting structure for the benefit of the child. And so when a parent is violating 2503, actually they're breaking the rule, and it is a criminal penal code. And when officers or law enforcement are failing to enforce that for whatever rationale they want to use, essentially they're allowing the offender to go free, and the offender gets the message. I'm going to call the violating parent, the offender, gets the message that, okay, well, I can get away with this and I can do it again. And sure enough, that will happen again. So actually what's happened is the law enforcement has allowed it to happen. They're actually propagating or enabling the process to occur. Now, many, from what I understand, law enforcement will refuse, saying it's a civil issue when it's not. And that may just be due to a lack of education or one type of influence or another. But there's another penal code called 1401, which really requires that an officer is to respond to a felony in view. So if you have a 2503 felony that's viewed by one parent, created by another parent, the officer is obligated to respond. And the one that really loses out on this whole situation is the child. And I think in the system, it's often lost of really who loses out and who really gets damaged. Of course, it's emotionally hurtful to the parent that is the victim of this, but the child is the one that loses the most. Now, according to Texas state statute in the family code, parents are to promote the parenting of the child with both parents. And if a parent cannot do that, that is really harmful to the child. There are proposals to do a stepwise ticketing process, which would be basically like a stepwise consequence for the offending parent. And just like getting a traffic ticket, with repeated offenses, the penalty gets more and more and more until actually the penalty may reach a felony stage. But signal-wise, looking at it as a red flag, by the time a parent, a custodial parent, is violating this rule, and not only violating the rule, but also not able to provide or promote the relationship of the child with both parents, then that would be a good indicator to switch primary custody. So another stage of the process that can occur that's enabling is when the issue gets put in front of the judiciary, and there's clear evidence that there's a violation of the statute. And I think what is forgotten is what is the impact, which is usually a negative impact on the parent-child relationship, the child, because the child also has a right to associate with both parents. That's their right, as well as the parent has a right to be a parent. And the same process of enablement can occur when evidence is brought forth that one parent has either once or several times violated 2503, and there's not a consequence for that by the judiciary, which essentially is enabling the violating parent. And enabling in the same sense that if law enforcement doesn't intervene, the process is being enabled or allowed to happen and promoted to happen. And this is damaging to the child. Separation with divorce or separation with non-cohabitation is a difficult process for even the healthiest adults. And it can bring about a lot of emotional turmoil. It can bring about a whole old baggage of emotional turmoil from either individual's past. And this can contaminate the present separation process. And when and if there's litigation, the litigation can be particularly difficult during the time of separation with high emotion, potential for high conflict, and the child or children can inevitably be brought in the middle. With exceptions, the science globally supports that shared parenting or 50-50 is an intervention that protects children. And again, I emphasize that with exception. It shields the child or children to allow them to have real-time interaction with each parent. And if there's contamination from one or both parents about the other parent to the child has enough of real-time exposure to both parents that they get their own perceptions of reality and can either validate what is negative or positive that's being told to them or invalidate it on their own. There's many authors that have written about the benefits of maximizing parent time for children, and knowing that the science supports that kids have the best outcomes in many different spheres or perspectives when they do have maximized time rather than the current possession orders in many states, including Texas. In addition, when the time is maximized and divided up as equally as possible, kids have less spans of a time, a span of time which is less that they're going without one or the other parent. And this is particularly more important the younger the child is. I spoke earlier about the perspective of time, which is much different when you're really young compared to when you're much older. Many authors, including Richard Warshak, Linda Nielsen, Edward Kruk, and many others across the world, have validated these findings. In particular, Linda Nielsen at Wake Forest, in her most recent review, I believe published in 2018, showed that when maximizing parent time, irrespective of parental conflict, irrespective of economic status, fared better on many scales. So it's hard to define and quantify what level of conflict, with some exceptions, occur in a married situation. And it's hard to define and quantify what level of conflict exists post-divorce or post-cohabitation. But this is one of the defining features that many, including the judiciary, as well as family law representatives, use to justify or not justify being able to have 50-50. when in fact, the research shows that 50-50 can actually more insulate a child from parental conflict than not. So 50-50 is viewed more as an intervention. And if there's an intervention that can benefit children, why not implement it? How does geographic location make an intervention less or more effective? Let's compare that to vaccines. Let's look at polio many decades ago that struck without warning, that had its own rate of illness that wouldn't get better despite rehab, and its own death rate in itself. It's similar to divorce and non-cohabitation that children have to endure. It's an issue that strikes without warning for them. They have no control over it. It has an emotional and psychological impact upon children, depending upon the age. Even with different types of therapy, sometimes that emotional and psychological impact doesn't improve, and they have their own different psychological, emotional illnesses later on in life. And there is a death rate. Suicide rates are much higher in children post-divorce and post-cohabitation than married situations, and much higher with children who have a loss of one of the parents. There are states now converting to the rebuttable presumption of 50-50. The most or the oldest would be Arizona, and there are follow-up studies from that state showing that litigation rates are on the decline. The ones least opposed to 50-50 rulings are actually the judiciary. The ones most opposed are actually the litigation attorneys. So if there's an intervention that can be helpful, just like a vaccine, and it's not implemented, and continued damage is allowed to occur, then the questions about ethical guidelines may want to be brought up. And questions about malfeasance or nonfeasance may be worthy of discussing.
As you can see, parental alienation happens to men, women. It doesn't discriminate against creed, race, or ethnicity. Doesn't care if you're Republican or Democrat. Parental alienation and the abuse that comes with it from those we think are there to protect us and to be equal and to have some type of integrity happens all the time. It is sad because many of those that we believe that are here to be on an equal standing, like a law enforcement, lawyers, district attorneys, as well as judges, will righteously and without any thinking whatsoever, will indiscriminately label a father or mother that is fighting to be part of their child's life as an aggressive parent, as a conflictive parent, as of an obsessive parent, as a parent that wants to cause turmoil. And once those labels are placed, the whole system will go after that parent indiscriminately. It happens all the time. Police will label and profile a father as a deadbeat before they even get to a scene of the crime, if you want to put it that way, because it is a crime that they're committing. It is not a civil matter, especially here in Texas. Interference with child custody is a crime. And they will label a parent. They'll look at a father down. They'll kind of demean him. It happens all the time. Not all police officers, but the vast majority does. Same thing happens in the court. If you go to the court, you start fighting for extra hours, extra days, weekends that you are not allowed to see your children, and you're going to be labeled a conflict parent, an obsessive parent. And once that occurs, the judge would, if he wants to or not help you out. If you have an attorney that is in the good side of the judge, then you might win a case or two. And this flips sides and the child grows up and realizes that they've been alienated from a good parent that loved them, the alienator more likely gets shunned away. And so for those of you that are going through alienation, keep fighting. Keep being part of your children's lives. Text them, send them letters. Okay? It's a horrible thing to go through. It exists. It's something that society knows that it exists. And those that are supposed to protect us from that aid in the continual barrage of attacks of an alienator. So with this, I leave you. We started with a tragedy of a father trying to go visit to see his child boyfriend in Lubbock, to a father that went for an exchange in Richmond and gets shot outside the police station. When is this going to stop? When are the police going to stop this? They're the ones that hold the key. They're the ones that need to enforce the laws. It's not a civil matter.
It's unbelievable. It's unreal.
Ty Jeffries can't believe her big brother, Stuart Jeffries, or as many knew him, Stu, is gone.
My brother was a loving dad. He was a loving brother. He was a loving son. All he wanted to do was work and take care of his child.
Jeffries was exchanging custody of his 8-year-old daughter, Mariah, at this Chester police station when the unthinkable happened.
They didn't have to go this far. All he wanted was his child.
His sister says he was meeting his ex-wife in this lot. We're told the ex-wife's new boyfriend, Corey Goodson Sr., was with her during the encounter. During that meeting, an on-duty officer heard a gunshot and later found Jeffries lifeless.
Now.